Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 21-1171, National Association of Broadcasters et al. Petitioners versus Federal Communications Commission and United States of America. Mr. Kinnear for the petitioners, Mr. Scher for the respondents.
Thank you. May it please the court. Section 317C of the Communications Act defines precisely broadcasters' duty of diligence in obtaining information necessary to announce the sponsor of paid programming. The broadcaster, quote, shall exercise reasonable diligence to obtain from its employees and from other persons with whom it deals directly, end quote, the necessary information. As this court held in Loveday, the language of 317C does not impose any duty of independent investigation. And Congress restricted the broadcaster's duty for a reason. Broadcasters are not investigatory bodies that are capable of determining the facts of private transactions. And especially in 1960, Congress would have understood that broadcasters, particularly in radio stations, were often small, sometimes single-person operations. These are country music DJs, local businessmen in small towns who sell advertising. They're not lawyers and analysts, certainly not capable of doing the sophisticated legal investigation that the order commands. And while the government attempts to downplay the investigations, paragraph 42 specifically says, we require the licensee to investigate the nature of the party leasing the airtime. And while every search of a database is an investigation, it is indisputable that if you get a hit in your search results, you have to conduct a full-fledged investigation. And for this regulation to have any arguable worth, you have to posit that there will be such hits, however implausible. And I think it's worth spending with the court a moment to understand what happens when you get a hit. And the broadcaster first has to then retrieve, locate registration statements of potentially multiple foreign principals. It has to know that there are 6-month supplements that are filed, and that it has to investigate these standard form exhibits A and B, disclose information about the principal and the activities undertaken. It then has to apply a specialized legal definition, which you can find at JA 237, that covers only a subset of FARA registrants. It's only those with principals that are foreign governments, foreign political parties, or an entity that's controlled, operated, or financed by such a government or political party. And then, critically, there's the final element of the definition, which says you have to be acting as an agent in this transaction, in your capacity as an agent. Now, that itself is a complex analysis because you have to apply the FARA exemptions. For example, the exemption for programming for fine arts, religious programming, scientific programming. But even then, you can't get an answer because the prospective information you need about this prospective programming is not to be found in the historical documents in the FARA or Section 722 database.
I can't quite tell if you're challenging the disclosure obligation or the specific language for the disclosure, or if you're just challenging the investigation.
We are challenging the investigational requirements. We would have no problem simply with an expanded disclosure, but we are challenging also the fact that we have to make compelled speech on our own behalf after undertaking this investigation, that this programming, specific programming, was paid for by person X on behalf of
Why is why is it compelled speech if it's a disclosure after the investigation, but it's not compelled speech if it's disclosure absent investigation?
It would be compelled speech either way.
But I thought you had just said you were not challenging the disclosure obligation by itself.
No, and if we had just had a disclosure obligation, I think that would be narrowly tailored.
Okay.
But if you have to do a disclosure after investigation, and this is the critical point, investigation that can't yield the information to make the disclosure. And so what's going to happen? A broadcaster is subject to forfeiture if it is found by the commission after the fact.
Why can't it yield? And maybe that's what you were just explaining, but why can the investigation not yield the information that you'd have to disclose?
Because the investigation, first of all, the documents in these databases are historical. That you file a registration statement, you update it every 6 months. When you're approached with a proposed lease, that's prospect. That's saying, I want to air this programming. That's not going to be in there. Whether you're the agent, who you're acting on behalf of with there, you can't find that out from the documents. So it just, that's something.
Is there any disclosure to the FCC before the program airs under the current regime?
No, and that would have been something they could have adopted something like that.
Well, yeah, and the reason I'm thinking is that you just identify the entity that is doing the, getting the lease and submit that to the FCC, and the FCC can do its investigation.
Well, the FCC didn't consider that kind of alternative.
Is there any information in the record that regarding voluntary or investigations by major broadcasting stations?
There isn't anything like that because it's simply not required.
Well, it's not required, but it strikes me that it would be prudent whether it was required or not, because if a program airs and it later turns out that it's Russian propaganda, that's not really in the interests of the station. So they may conduct the investigation anyway, just to cover themselves.
Right, but there's
nothing in the record indicating
the record doesn't indicate any voluntary investigation.
So, Mr. Kennard, I take it the core of your case is about the narrow scope of the diligence to obtain from employees or lessees. Right. Is it within the commission's authority to, in obtaining information from lessees, to require that lessees submit a screenshot of the page of the FARA where the sponsors would appear alphabetically, and just to show that they're not on the FARA list?
Absolutely. They could have imposed that kind of obligation on lessees and derived from Section 507, where you have to disclose any information you have about the payor. So that would have been perfectly reasonable to do.
And is that meaningfully different from what the rule does require?
I think it would achieve the same results, but it wouldn't burden the speech of broadcast. And I'd like to emphasize the point about forfeitures. Generally, forfeitures under Section 503 of the Act require willful or repeated violations of a regulation. But Congress in 1960, when it created Section 317C, created effectively a strict liability forfeiture for violations of 317C, which underscores the narrowness of that provision. But it also shows you the risk to the broadcaster if it's not certain and in terms of whether there's a foreign governmental entity. And so the default is, hey, if this is a close call, I'm just not going to carry the programming. And so that's going to chill speech. Are they going to carry the local Vietnamese immigrant community if they think, I'm not confident I can find this in the FARA database? So that's part of the chilling of speech. I would also emphasize 3 points with regards to chilling. The first is that any restriction on speech has to be to identify real harms and alleviate them to a material degree. Because the commission narrowed the scope of the investigation, it basically has limited it to FARA registrants who lie about their own status, something never known to occur not predicted to occur. I see I'm into my time, so.
Well, or people who have obtained information from someone that they didn't realize was a FARA registrant. It seems like that's the more likely situation. I mean, you're right that somebody could be just lying, but they could also be getting information, getting programming that was,
they could be,
that was developed as propaganda that they don't realize was developed.
That's quite possible, Your Honor.
Yeah.
And I think there's also the fact that, as I mentioned, you can't actually get the information from the prescribed investigation. And finally, it's such overkill because by triggering investigations universally after every denial in an industry where almost all leasing is by domestic or private transactions, you're going to burden a lot more speech.
What's your response to the FCC's claim that the boilerplate language that you find in many statutes that says that you must promulgate appropriate rules and regulations to carry out the provisions? It's the Morning versus Family Publication Service issue.
But I think the court's precedents are clear that it doesn't allow you to overcome limitations in the statute that you're carrying out. So they can't erase the restriction. And reasonable diligence has to have a predicate. There has to be diligence to do something. And Congress defined that predicate was to obtain from specific sources. So the commission's not entitled to violate.
Your position, as I understand, is pretty simple. That under the statute, the only information that you're required to get is from the individual who is seeking to lease.
Right.
Right.
That's right.
And that's it.
That's it.
And to get it from the database at the Department of Justice on the Foreign Agents Registration Act, that's not getting it from the
exactly.
That's getting it from the government.
Right. There's a bright line, and if the court were to accept the commission's erasure of the bright line, that's going to inject uncertainty beyond this rule, because in case by case, if reasonable diligence can include online searches, then in every case the broadcaster asks, well, for this particular transaction, do I have to do an internet search or a public database search? So really, I think the commission has to abide by the language that Congress imposed.
Mr. Gunnar, do you know why the statute includes the due diligence from the licensee's employees?
Yes,
what's that about?
That's primarily pertains to Section 317. I think it's D, where if the payment is not made to the licensee itself, you also have to disclose if it was made to somebody else. So this goes back to the payola scandals, where record companies, for example, were paying off DJs and they weren't necessarily paying the licensee himself. So you want to have reasonable diligence to uncover any payments to the employees that are not payments to this licensee, because you have to make that separate announcement under 317. I forget whether it's offhand, whether it's C or D, but it's different from the payments to the licensee.
Thank you.
Thank you.
We'll give you a little bit of time for rebuttal. Morning.
Morning, may it please the court. Bill Scher on behalf of respondents. The FCC adopted the challenged rule in response to reports that foreign governments are sponsoring broadcast programs without announcement of their role. The rule requires, among other things, a simple name check to confirm that an entity leasing airtime is not registered as a foreign agent or a US-based foreign media. To be clear, the name check is the only statutory issue in this case. The rule's other reasonable diligence requirements involve inquiries to lessees, which pose no problem even under NAB's reading of the statute. The name check requirement is consistent with the statute. Section 317C imposes a duty on licensees to diligently seek sponsorship information from persons with whom they deal directly. The name check is integral to that duty. It confirms the information that licensees obtain from the source the statute specifies. Now, NAB argues that the plain language of 317C bars such a requirement, but the statute doesn't use the word only or provide any other clue that Congress intended to shield licensees from ever having to confirm sponsorship information.
And why doesn't that make the phrase "from the employees" or the people it deals with directly surplusage?
The phrase "from persons with whom it deals directly" specifies the nature of the duty. licensees must seek sponsorship information from those particular individuals, and it matches up with the disclosure obligation imposed by other provisions of the statute, Section 508. But there's nothing restrictive about the specification, the description. So, and in fact, if you flip it and read from persons with whom it deals directly as restrictive, I think then you end up with surplusage with the term reasonable diligence, because if Congress meant to strictly limit the duty to simply asking for sponsorship information from a certain source and never checking it, then it's not clear why Congress would have used a broad term like reasonable diligence. So there's some tension there, and we would also maintain that there's tension between a restrictive reading of the statute and Section 317E, which gives the Commission authority to implement the sponsorship identification requirement.
So if the statute said I could get a broadcast license from the FCC, assuming I meet certain criteria, could I then go to the FEC and ask them for a broadcast license under the argument that, well, it didn't say I could only obtain a license from the FCC?
Your Honor, clearly if there's, the statute doesn't have to include words like only, and certainly the mere fact that it specifies from X doesn't mean that Y is allowed. But under the case law, in order to find that the specification of one thing excludes another thing, the negative inference, there has to be some clue in the statute that Congress's intent was in fact restrictive, and we would maintain that the dependent clause in and of itself is not inherently restrictive, and there's simply no other statutory clues to a restrictive intent.
You are conceding in a sense that what the FCC is requiring here goes beyond an obligation to obtain information from the licensee's employees and beyond an obligation to obtain information from the people the licensee deals with.
No, Your Honor, we have two arguments. Our first argument is that the name check is integral, is corollary to the express duty that the statute imposes to seek information from the persons that the statute.
The other thing is in the alternative.
So in the alternative, if the court finds that Section 317C silent or doesn't, the breadth of the duty that's expressly or implicitly imposed by 317C doesn't encompass a name check, it's our position that the Commission still has the authority to impose a name check under 317E, provided that 317C isn't read as a proscription on that. But again, it's our position that there's.
Do you have any kind of limiting principle on how far the FCC could go under that second theory?
Well, certainly the FCC couldn't require broadcasters to seek information from elsewhere instead of the statutory obligation. And that actually leads me into the nature of the investigation that we're talking about here. The name check requirement, under the rule, broadcasters, if they receive a negative response to their inquiries as to whether the lessee is a registered agent or US-based media outlet, are required to type in a name into the FARA database. And that is the only inquiry that the rule requires.
I get that that's this case, and the broadcasters say, well, there's more to it than that. But I want to go back a second. I'm not sure I heard a limiting principle, because what you said is, well, it wouldn't be proper for the FCC to do less than they do. But I'm asking, is there any limit on how much more they could do than they've done?
I think that certainly the Commission would run into the kind of constitutional problems that the Loveday Court articulated if it were to require the kind of open-ended investigation.
That's the only limit? The statute is limitless until it hits the constitutional limit?
I don't think that the statute imposes an express limit. So I think the commission could not override the express duty that it imposes.
And do you agree with Mr. Kinnaird about the employees designation in the statute, which puzzled me in reading it?
Your Honor, my understanding is that Congress, when it amended the sponsorship identification regulations in 1960, there was a recognition that payments were being made in the chain of program production. Payments were being made to employees specifically and not to licensees. And so Congress imposed the duty to seek out information from sources other than the licensee. And there's I think it's 317B, requires that if a payment is made, that if it were made to the licensee itself, to an employee or some other person, that an announcement is required regardless.
Mm-hmm. And so am I correct that your argument, your statutory argument before you revert to 317E is basically to say the licensee shall exercise reasonable diligence to obtain valid information from employees and lessees, and that it's still only getting the information from the employees and lessees, but it has this sort of minimal obligation to backstop that by looking at the FARA registry?
That's exactly right, Your Honor. And in a situation like this, where the commission has defined foreign governmental entities based on appearance on a list of registered agents, we would maintain that reasonable diligence means ordinary prudence under the circumstances. And when there's readily available evidence and the only burden is to type a name into a government list, we would maintain that a reasonably diligent broadcaster would do that in order to be sure of the credibility of the sponsorship information.
And what are your responses? Mr. Kinnaird made a couple of arguments about the FARA registry not even being up to the minute in terms of accuracy, and that if you do get a hit, you have to do a whole bunch of other investigations. So you're characterizing this as a very, very, very minimal additional burden, and he's characterizing it as a very onerous and amorphous obligation. Can you respond to his arguments on that regard?
Yes, Your Honor. Again, as I started off saying, the statutory issue here is the independent investigation, the requirement to look outside of what the lessee has responded to the licensee. The name check is the beginning and the end of that requirement in terms of what the rule actually insists on. So in the event that a lessee's name turns up in the FARA database, that means that an alarm has gone off. There's the lessee has informed the licensee, I'm not registered. The lessee's name has appeared. So in that situation, there's an alarm, and I think that the necessity for the rule, the importance of the rule, has been served. And at that point, what the licensee's obligation is tracks the statute completely. The licensee's obligation is to exercise reasonable diligence to get sponsorship information and to make the announcement that's required. The Commission's rules have imposed an obligation to identify and announce the true sponsor rather than the named sponsor if the licensee is aware of the true sponsor since 1975. And the Commission's rule and the order don't impose any requirement. I mean, the FARA statute, I think, contemplates that the information the licensee would need should be available in the registration statement. They're not that complicated, but the important point, I think, is that the rule doesn't actually require licensees to dig any further in the FARA database than the name search. In the event that alarm goes off, all the licensee is required to do is to exercise reasonable diligence to make an announcement. If it goes further in the FARA database and discovers that there's an announcement necessary, it can make that announcement. It can go back to the lessee and make additional inquiries if it needs to.
And would it serve the government's interest were you to not prevail, I mean, just hypothetically, were you not to prevail in this case, would it serve the Commission's interest, and would it be consistent with the statute in your view, if the commission required licensees to ask, as I mentioned to Mr. Canary, to ask lessees to provide the relevant FARA page showing that their sponsors are not listed where they would otherwise appear.
I think that that would accomplish the exact same thing. And the only thing that I would add to Mr. Kennard's response is that that would have to be a requirement that licensees obtain the information from the lessee. So if the licensee were to make the required inquiries and to also say, I'm going to need proof in the form of a website snapshot or whatever it is, and you have to submit that to me, I think that would accomplish the same thing as long as it was a requirement on the licensee, because the statute imposes requirements directly on licensees.
So the licensee shall require that lessees provide to them this information.
I think that would accomplish the same
exact
purpose.
same thing.
Yeah. I think that points out how limited the scope of the required independent inquiry is. I see that my time is up.
Yeah.
A couple of times, maybe more than a couple of times, you've suggested this is a pretty simple, quick, easy name search. And I'm not going to do justice to the broadcaster's argument. I'll let them maybe mention this in rebuttal, but you know what it is, so you can anticipate it. They say, well, you might go to FARA and you might find that the lessee's name is there. That doesn't necessarily mean that the lessee is acting as an agent of a foreign government in the context of the broadcast in question. And there might be 2,000 pages on FARA dealing with that lessee's relationships with foreign governments. And so it's not like you look in the phone book, their name is there or it's not there. It might be, look at FARA, their name is there, and you've got 40 more hours of investigation to go before you can figure out whether there's some kind of duty trigger. So what's your response to that?
So a couple of things, Your Honor. First of all, the rule doesn't require licensees to do any further investigation on that database. They can simply go back to the lessee at that point and make further inquiries of the lessee. And the broadcasters are not arguing that the inquiries to a lessee are outside of the scope of the statute or that they violate the Constitution, I believe. In addition, if you look at the FARA statute, it specifically requires that the registration statement provide a clear explanation of who an agent's foreign principals are, what its activities are on behalf of each one, and whether any of those activities are connected to a foreign government or a foreign political party. The registration statements are not long in general, and I recognize that there's a burden entailed, but it's a burden. It's essentially, we would sort of argue, no harm, no foul. The additional burden is going to attach when an alarm has gone off. And these licensees are public trustees. These sponsorship identification regulations have applied to them for over 80 years, and the commission believes that this is an area.
I just want to make sure I understood the first part. I don't think this matters if you lose on the statutory grounds, but if we were to get to the APA or maybe the First Amendment question, it might matter. You're saying if the licensee found a hit on FARA, they found that the lessee's name was on FARA, rather than digging through possibly 2,000 pages of FARA information about that lessee, they could just go to the lessee, say, we found your name on FARA. Are you an agent of a foreign government? The lessee says no, and that's the end of the investigation. That would be enough?
Your Honor, whether it's enough would depend on the statutory standard of reasonable diligence. But we said in our brief, and I'll repeat, that the rule doesn't require any further digging in the FARA database. Whether further investigation in the FARA database occurs is up to the discretion of the broadcaster in the particular case. It may be that the lessee says, oh yeah, it turns out I am a registered agent. It's for different activities. Let me provide you with a statement about that. End of story. If the lessee doesn't have any explanation, then a reasonably diligent broadcaster might want to take another look at the FAR database.
So is part of your point, Mr. Scher, that the burden is not a burden specific to alarms that are set off by a FAR listing? It's a burden whenever an alarm about foreign ownership or sponsorship arises, and therefore it's not specific to this rule?
It's specific to the rule, but I guess my point is that the government's interest is heightened in cases where the alarm has gone off. And so there's a greater duty of diligence because there's a greater risk that hidden foreign governmental sponsorship could be going on.
Because there's been a failure of a relevant disclosure? No.
Yes, because the fact of registration indicates a risk that there is an entity that's acting on behalf of a foreign government, and also because, that's the reason.
Right. I thought you were making an argument about the burden not being a burden associated with this particular incremental rule, and that if somebody, for example, discloses, I got this programming from so-and-so, who, by the way, is on the FARA list, that there would be, and they would say, well, but not with respect to this, or that's an old list, or, that in that situation, which doesn't implicate the challenge rule, all the burdens would be the same.
Yes, that's correct. Under the framework of the pre-existing rules, there was a duty of reasonable diligence. There was a requirement to make a sponsorship announcement. What the rule does is essentially clarify the nature of that duty by defining what a foreign governmental entity is with respect to an objective source.
All right.
Thank you.
Thank you. So, Mr. Kinnear, you've used your time, but as I said, we'll give you a couple of minutes for rebuttal.
Thank you. I'd like to make just 4 quick points. I heard my colleague say that the statute imposes reasonable diligence to get the sponsorship information. That's not what the statute says. The commission is excising the from clause. And to Judge Walker's point, there is no limiting principle of the commission's construction. I would advert the court to JA 162, an earlier version of this order, where in addition to the FARA searches, the commission proposed internet searches, and they haven't disclaimed that that's part of their authority. Second, in terms, and I would also add, they said the statute does not use the word only. Well, if you use the word only, you would preclude the kind of voluntary due diligence that Judge Randolph discussed. The reasonable diligence, they define the scope of it. The commission has to obey that bright line. On the point about the 1975 regulation and always having a rule to go and exercise diligence to find the true sponsor, if you look at 73.1212 B and E, you can see that's only diligence to make inquiries to the persons with whom you deal directly. As I heard my colleague agree with Judge Pilar that it would be sufficient to just ask the licensee to disclose that information. I think that answers the question about whether this is narrowly tailored. There's a less restrictive means. And I don't think that the commission is really grappling with what happens because of the radical indeterminacy of these investigations. He said today, well, you could just go back to the licensee. The order doesn't say that. That's an APA violation, failure to explain. But even in their brief, footnote 4 on page 11 says you can go back to the licensee or you can take other appropriate steps. Indeterminate, but it's certainly an investigation beyond the purview of the statute. And I would just urge that there is no simple name check except for the extreme overkill of this regulation that triggers investigations for truly domestic lessees, for your George Foreman grill infomercial, for your local Baptist church. This is an ill-conceived regulation that is unlawful in multiple dimensions. Thank you.
Case is submitted.
Case number 21-7036 et al. A state of Jeremy Isidore Levin et al. Appellants versus Wells Fargo Bank N.A. Ms. Smith for the appellant, a state of Jeremy Isidore Levin. Mr. McGill for the appellant, James Owens. Mr. Locatos for the appellee, Wells Fargo Bank N.A. Mr. Hudak for the appellee, United States.
Good morning.
Good morning, Your Honors. It's great to be here in person. Your time is valuable, my time is short. So I'd like to make a couple of points from a 20,000-foot perspective that I hope will guide the panel in its resolution of this decision. In 1984, Jerry Levin escaped from captivity, being held hostage by Hezbollah for over a year, tortured. It was a miracle. He came home, but he was broken. He was broken because he was tortured, starved, lost his hearing, had many medical problems. There were medical bills, the Levins had to sell their home, and there was no one to really turn to for help in terms of getting compensation for all the wrongs that were done. You could get a judgment against Iran, but you couldn't collect it, practically speaking. Then in 2002, another miracle happened. The TRIA was passed by Congress, and TRIA opened up a whole new area of potential collection for the judgment holders, the victims who had been the victims of terrorism. And TRIA says that you can get the blocked assets of a terrorist state or its agents or instrumentalities, blocked assets blocked by the government, by OFAC, by Treasury, not assets that the victims and their lawyers go out and find and block, but blocked assets. Originally, it was being interpreted by most judges in the district courts in New York that TRIA permitted EFT blocked assets to also be collected on. And we did collect some of our judgment on those EFTs and other blocked assets in New York. Then in about 2008, Calderon came down and the Second Circuit changed the law. And the Second Circuit said that EFTs, different from any other kinds of blocked assets, but EFTs cannot be collected on. And in order to support that decision, the Second Circuit looked at New York state law, the UCC, to create that rule of law.
Before that decision, were courts using the agency theory of ownership that you propose that we use in this case?
I'm sorry, Your Honor, I'm having a hard time hearing you.
I'm sorry.
Forgive me.
Before that case, were courts using the agency theory of ownership that you propose in this case?
So they were using a number of different approaches. Agency theory was one of them. They were also looking at the purpose of TRIA and the language of the regulations that the president.
The Massachusetts rule, is that what courts were using, that particular theory?
The Massachusetts rule is part of what the district courts were looking at before Calderon. Common law, TRIA itself, the regulations, the OFAC regulations, all of that was being looked at.
I sense a little bit of hedging in your answer, which I appreciate. It sounds like you're just trying to be accurate about it, but it sounds like they weren't using the kind of pure agency Massachusetts rule that's been proposed in this case. They were using maybe more of a multi-factor standard, and that was part of the standard.
So I think, Your Honor, that's right. It was multifactored, and just so that it's clear, I think that the Massachusetts rule gets this court to the place that it should get, that the victim should be able to collect. But I also think that this court, in its Heiser decision, departed from what Calderon did in the Second Circuit and took a different look at the UCC. So I think you get there either way. I think if you look at the UCC as the professors, the amicus briefs, and the professors who teach UCC law understand at a deep level. And by the way, it's notable that no court has really parsed the UCC in depth. There are a lot of interpretations of it. There's a lot of paraphrasing, but there's no court that has taken a deep dive and actually quoted from the UCC itself at length and the comments to the UCC, which under the money-back guarantee rule, which Heiser recognized, which the Second Circuit did not discuss at all, and which the district court here did not discuss at all. The money-back guarantee explains that when you have your money, and everybody agrees it's money of, hey, the terrorist in the beginning, that's where it comes from, that's the origin of it. When you take your money and you put your money into the commercial transaction to buy a ship, as it was in this case, or something else, and it goes through a bunch of different banks in the process of the EFT, the person whose money it was originally does not lose all rights to their property, such that some bank along the way becomes the absolute owner of that property. The originator, the person at where it starts, retains some property rights, as the professors explain in great detail, and that's what
Can I ask you,
the court said in Heiser.
I've been trying to figure out, your client filed a writ of attachment, right? Both in DC and in South Dakota, is that right?
In South Dakota, yes, sir.
Right. And the Owens plaintiffs filed a writ of attachment in DC, and the government filed a writ of attachment in DC, and the government was first, right? So it seems to me that if the law is that the government, because it filed first, has priority, then for us to decide the issue that you present would be giving an advisory opinion, because you're not going to be able to get these funds anyway. So my question is long-winded, but my question is, what is the law with respect to priorities in when several parties, several debtors file close to each other in time?
So, Your Honor, the law as to priorities, we believe, is that the TRIA, which has the notwithstanding language, gives the priority for TRIA victims and TRIA judgment holders to any blocked assets. And that would include when the government is trying to go through forfeiture, which is a whole different process.
Okay, so that gets the government out of the picture. But then between you and the Owens,
where do we go?
Yeah.
So, yes. So where we would go if we fight it out to the bitter end is that we would have in the district court, we would have a priority contest. And our position would be that the rules require the writ to be filed where the assets actually are in South Dakota. And the person who goes there first gets the priority. The reason we were in DC is because the forfeiture action was here and it made sense to have decisions being made here, but the issue of priority between Owens and the Levins has not been decided, and it would have to be decided below. And I will tell you just practically, sometimes we work it out before we get to that point and we decide to share rather than fight each other down to the death. But you could go. You could go.
Several other questions that relate to the UCC itself. To apply the subrogation rule, you have to know who gave the instruction to the originator's bank, right? And the record here doesn't tell us that. It could have been just the law firm, Holman. And if that's the case, then there is no violation of the originator's instructions. And so there would be subrogation. So who is it that gave the instruction to use the New York Mellon Bank?
So the originator, the terrorist entity, told its lawyer to tell Lloyd's Bank to use Mellon Bank. And that's the way that chain worked. So the client...
But at the time, Holman was representing was an escrow agent and was representing not only TAF or whatever, but also Crystal. It was a joint representation. So it wasn't just, it couldn't have been that they were simply following the instructions just of TAFE.
Okay. So
Is that correct? I mean, they were jointly representing them, right?
So the law firm had a dual representation, as it were. It was an escrow agent, but it was also more than that. It was the lawyer for the terrorist TAFE. I'm going to call it TAFE. I'm not sure I'm saying it right either, but TAFE. They were the law firm advising TAFE on the transaction and perhaps other things. Remember, we're at the pleading stage here, so what we know is what we put into our pleadings and what the government put in its pleadings. But it had a dual purpose. It was representing Crystal and TAFE as escrow holder, but also TAFE as advisor in the entire transaction. So it was a law firm to TAFE.
The other question I have is not dependent. I don't think it's dependent on the UCC, but it occurs to me that one of the objectives of this is not only to satisfy the judgment, but also to put pressure and control over terrorist activities, right? But I'm not sure that would be accomplished either by your lights or even by the governments here, because whether TAFE is out of its $10 million or whatever it was, it would depend upon English law, wouldn't it?
No, it depends upon American law, because the TRIA...
Well, let me put it this way. Why, if they're out of the money, because Lloyd's used an American bank, or Wells Fargo, then why wouldn't, I don't know what English law is, but it would seem to me that TAFE would have an action against Lloyd's of London and collect the $10 million from them.
Somebody may or may not have an action against Lloyd's of London in England, but United States law, Your Honor, governs this action and what happens vis-a-vis the victims collecting. And the reason it serves the public purpose of the terrorist regulations is you take that money out of any possibility of going upstream back to the terrorist. And there are circumstances where that might happen. Many, many years could go by, and it could be that these circumstances...
Well, it seems to me there might be an action against the law firm, too. I mean, of all the places to use as an intermediary, it uses the intermediary of an American bank knowing full well that there was blocking going on. I mean, that seems to me crazy. Why not use a bank in Malaysia or something?
Well, that's a question.
As a practical matter, are there cases in which judgment creditors identify transactions and alert OFAC to freeze? I'm thinking about the question that Judge Randolph is asking about, in what sense does your reading of the statute serve the interests of depriving terrorists of resources? And so I'm just wondering, as a practical matter, whether the plaintiffs being interested in any way prompts or aids the government's asset freezing activities.
So it does in this way. The government, of course, has access to much more information than private lawyers, although we have spent lots of money, millions of dollars over time, with private investigators trying to find assets that are money laundered, that belong to the terrorists. And we've had some success. But the other thing that allowing the private actions to go forward does, even though the government wants its forfeiture action all by itself, there are cases, there's one in New York, in Ray 650 Fifth Avenue, where there are TRIA cases and forfeiture action going in parallel, and we're working together with government. We're taking depositions, they're taking depositions. They're getting documents, we're getting documents. So we do work side by side when the court says that the victims are...
Specifically, would it ever be in plaintiff's interest to trigger a freezing or not? Would it be better for plaintiffs to say, we just want to attach this and not have the government even be?
No, in my opinion, it's always better when the government has blocked the assets, because then we have TRIA with a notwithstanding language. We go after the blocked assets. When those assets are available, it's a pretty clear path, which is why if the Heiser rule, which says the originator has an interest and we're allowed to go after these assets, then our course is pretty well charted.
And your argument is that the government comes back and says, look, we get this fund or these deposits, so we put it into a fund so that all of the judgment debtors would have at least a shot at having partial satisfaction. And your response is the problem with that is that the government has to will skim off 25% off the top.
That's part of it. For the
let me just take that point.
Yes.
Right? But I'm not asking you to disclose your attorney-client relationship, but it seems to me common sense that you're doing this on a contingent fee. And if your contingent fee is, say, 30%, then there's more in the pot than if the government takes it, because you're going to skim off 30% of the recovery anyway.
So skim, Your Honor, is kind of a loaded word. But yes, but most of these cases are done on contingent fee. But for the court to be absolutely clear about this, the Levins are not part of the fund and cannot be. Some people are, some people aren't. You have to give up a lot in order to be part of the fund, and the government does take a big share for its all of the fees, if you wish.
What do you have to give up?
Sorry?
What do you have to give up other than the government's 25%?
So you have to give up certain rights to other causes of action, that other assets that you're going after in different locations. So I mentioned the 650 Fifth Avenue case. That's part of it. There was a time window to go into the victims fund. That window has closed. And also there's an amount, a cap on how much you can recover. And the Levins have not quite reached that cap, but we're approaching it. And our $30 million judgment, which the DC court found was a conservative compensatory.
That's all compensatory?
All compensatory. We didn't even seek punitive damages because, frankly, we thought, let's just stick with compensatory and try to collect those. So
we have held already that does require a property determination. What is exactly the rule that you would require, that you would ask us to adopt to determine whether the blocked assets are property of?
So it's the rule that was articulated in the Heiser decision. That rule says the originator has a property interest in blocked assets that come from an EFT. So if the funds were originated by the terrorist, there is a property interest in the terrorist, notwithstanding the use of an EFT to facilitate the commercial transaction.
It doesn't say property interest, it says claims, correct?
Yes, you're right. Claims. And we say and argue, Your Honor, that claims are a property interest, but you're absolutely right. The word is claims. The claims, the originator still has claims against that property. That property does not become property of a bank, as the district court.
It's an advantage to you, to your clients, that the government blocked these assets.
Yes.
And in the blocking statute, it doesn't say interest in ownership. It just says any interest. And I'm going to ask the government this because it seems to me somewhat inconsistent for the government to argue that Iran doesn't have any interest or has an interest in this, but Iran doesn't when it comes to your recovery. Do you have any clue what the interest that the government is talking about when it blocked these assets?
They're talking about the interest of Iran in its funds that were put into the United States commercial system, which is forbidden by law. And the government recognizes that the whole reason the government can go after this in forfeiture is that Iran and TAIF started this unlawful, illegal transaction, which came into the United States system.
All right, we'll hear from Ms. Miguel. Thank you, Ms. Smith.
Thank you, Judge Pillard. May it please the court. It is indeed good to be back in court. I just want to start by addressing some of the questions you asked, Judge Randolph. You asked where the instruction to use the intermediary comes from. I would point the court to Joint Appendix 166.
That's the Holman letter?
That is the Holman letter signed for and by James Wright, attorney for and on behalf
Yeah, I know
of
they said that. Yeah.
Safe Mining Services.
Yeah.
You asked a question about the scope of the Holman representation, and I would point the court to Joint Appendix 117 to 121, which is sealed. So I'm not going to talk further about it, but that establishes that Holman is not acting simply as an escrow agent on behalf of both, but there was a separate representation. You asked why the government's filing of the forfeiture action doesn't resolve the case. It's because the mere filing of the forfeiture action doesn't establish a lien on the property. And this is a subject that I expect we may have further litigation with the government about, but certainly the district court could have resolved the case in the government's favor if that were the case, and it's not. You asked why not use a Malaysian bank. You need this transaction under the contract was to be conducted in US dollars, and you need to go through a US dollar bank.
Where is Crystal located?
Crystal Holdings is a Greek company. It's a Liberian affiliate of a Greek company. Okay. You asked about the Victims Fund. My clients are participants in the Victims Fund. If the notwithstanding language of TRIA means anything at all, it means that we can recover under TRIA, notwithstanding the existence of the Victims Fund remedy. And it is, I would maintain, the government is quite wrong to suggest that Congress, in enacting the Victims Fund, meant to limit terrorist victims' access to other remedies. You asked about the interest in property here, or the government's, what is the interest in property? I would just point the court to Joint Appendix 170, which is the blocking order, which says that the specific...
Oh, let me grab that. 170?
170.
Yeah.
And it says that OFAC believes that the specifically designated global terrorist, which here is TAFE, quote, has an interest in the funds involved in the electronic transfer identified below.
Where is that in the first paragraph?
That's in the first paragraph, 3 lines from the bottom, Your Honor. 3 full lines.
I see. Has an interest
in the funds identified below, and then it identifies...
Well, that just tracks the statutory language.
Actually, the statutory language, Your Honor, does refer to property or an interest in property. So it does require not merely any interest, and that...
Oh, wait a minute.
That is 50 USC 1702B.
One,
right.
1B,
which refers to...
in which any foreign country or national thereof has any interest.
With respect to any property.
Yeah. But
subject to the jurisdiction.
So what I asked is whether that means that, whether that covers something other than ownership interest.
The government will provide its own answer to that question. Yeah. I would submit that it embraces at least TAFE's continuing interest in the use of the funds that it would have if not blocked, which of course is a primary incident of ownership.
But there is some potential daylight between that and our reading in Kaiser that of means property interest.
Absolutely.
As opposed to interest in.
I'm not arguing that the blocking regulations are coextensive with ownership. That is not our argument, but it's different than Heiser. In Heiser, the interest was a future contingent possessory interest.
Right.
TAFE is the undisputed only source of these funds, right? The Lloyd's Capital, Wells Capital did not contribute to this transaction. TAFE is the sole source of the funds. That is the opposite of the facts in Heiser. right? And in Heiser, somebody else's funds were just going to pass through the Iranian bank on the way to the end. My time is running really short, but for 3 reasons, this court should not determine ownership of a blocked asset solely by reference to Article 4A's subrogation provision. The first is that Heiser certainly did not command it. As my colleague said, Heiser instead looked to quote the principles of Article 4A, and from that concluded that, quote, claims on an interrupted fund transfer ultimately belong to the administrator. And indeed, in Heiser, if you look at the district court opinion, Judge Lambert's opinion, page 447 at footnote 3, it says that it talks about the uncontested transactions in Heiser. And in Heiser, that the transactions where the Iranian entity was the originator or the originator's bank, it was conceded that it was attachable. So it was conceded, at least up till the point of Heiser, that if Iran was the originator, it was attachable. So Heiser doesn't command it. The second point is that the risk allocation rationale of the subrogation provision is completely absent here.
Just on that, was the government participant in the district court?
In the Court of Appeals it was, but not in the district
court.
But not in the district court, but also in this court's opinion in footnote 3, it refers to the uncontested transactions. And certainly if it were the case that Article 4A and the subrogation provision was to be mechanically applied as the only way to determine ownership, I would have expected the government to have said something at that point in time, but it did not. The risk allocation rationale.
So I'm a little bit confused. Is it your position that, number one, a proper interpretation of Article 4A would result in a reversal of the district court's opinion, and that if not, then we should promulgate another common law decision to take care of this particular situation, which is, or is it both?
It's not both. If you mechanically apply the subrogation provision here, then because Lloyd's used Wells instead of Bank of New York Mellon, as the instruction reflects that I cited, because they used a different bank, then under 402E, Lloyd's has the claim against Wells. And if the instruction had been followed, Tate would have the claim against Wells. So we would acknowledge that under a mechanical application of 402E, we, as the district court said, are out of luck. That we would submit makes no sense at all as a matter of, when you line it up against the purpose of TRIA. It's impossible for me to believe that the Congress that enacted TRIA would have wanted ownership to turn on such a happenstance. And this is, the more important point is that the rationale of that loss allocation provision has no footing here because there is no claim against Lloyd's. As Wells says at pages 17 and 18 of its brief, Tate can have no claim against Wells, certainly not under Article 4A, which doesn't apply in the United Kingdom at all. But as Wells says, under the terms and conditions of Lloyd's banking agreement, it's highly likely that Tate has no claim. And why? Because the transaction was illegal from the get-go. There is nothing this is not something that Article 4A was designed to deal with. And that is our kind of...
Well, I'm wondering whether it was designed to deal with blocked assets at all.
That's correct. It wasn't. And, but it certainly wasn't meant to deal with illegal transactions. It was meant to allocate loss. Talking about the subrogation provision specifically, it's intended to allocate loss against the risk of an intermediary bank failure. and it allocates that loss to the person who chooses the intermediary bank. That's a sensible rule. If you choose the intermediary bank, you are stuck with the loss. You are stuck collecting against that basically empty pocket.
And Mr. McGill, when you say an intermediary bank failure, what are the common kinds of failures you're talking about? I mean, it's not just...
While a wire transfer is proceeding, the FDIC closes the bank because it...
So the bank actually going under,
fails.
There must be a bunch of other kinds of errors or mishaps that this...
Sure, when a transaction miscarries, but that's not, so then the risk of loss is effectively minimal, right? The risk of loss is zero. If the transaction miscarries for some reason or another, then Lloyd's would, in this case, Lloyd's would go to Wells and say, you've got to pay me because I have to pay TAFE. And that's a sensible rule, and it's what essentially Heiser says at the end of its opinion, that we unravel these transactions backwards. And
when you say miscarries, what you mean it doesn't happen, or the money gets sent off to the wrong place, or just in common sense terms?
I wish I could say in common sense. I'm just parroting what the language of Article 4A in the comments. So what they meant by it, I think just is that they try to embrace all the possible rationale or ways in which a transaction could go bad. But the primary one they talk about in the comments is if the bank quote suspends payments, which means if it fails. And so that's what 402E is all about. It's about allocating the risk of loss. But here, as Wells says, the risk of loss lies with TAFE. Why? Because the transaction was illegal from the beginning.
Well, was it illegal from the beginning? I'm not sure about that, because it became illegal only because it was using an American bank. If they had used all foreign banks, there's no illegality that I see.
I'll take that point, Judge Randolph. But what I meant with the transaction from the beginning was in U.S. dollars and contemplated use of the U.S. banking system.
So does TAFE not have a claim against Lloyd's, because Lloyd's was the one who chose Wells Fargo?
Not according to Wells. And TAFE they're terrorists and pirates. I mean, they're not going to come to court in London and say, we want our $10 million back from Lloyd's. But I would put two things on the table. One is page 17 and 18 of Wells's brief, where they say that it's very likely that Lloyd's doesn't have any claim against it from TAFE. Two, Lloyd's has never shown up in 2 years. They apparently are not very interested in this case, and that makes sense because none of their capital is at risk. And three, there is Article 4A statute of repose, which is Section 505, which generally provides for a 1-year claim limitation. However, again, Article 4A doesn't apply in the UK, so it's not. This is just yet another reason why Article 4A is not a perfect fit for blocked terrorist transactions, which are almost definitionally international.
One of the virtues of federal common law is that no matter where you go in the country, you'll be dealing with the same law. If we split with the Second Circuit, the government says that's going to encourage form shopping in cases like this. What's your response to that?
I would expect the government would seek review in the Supreme Court if that's a serious concern, and resolve it that way. But I think I'm not going to dismiss the reality that if you adopt my rule, then people can win here and not win in the Second Circuit. But the Second Circuit doesn't apply federal common law. The Second Circuit applies New York state law, which they have said they must mechanically apply the UCC. And my meta point to the panel is that makes no sense in this situation. Article 4A doesn't deal with blocked transactions at all. It's not intended to deal with terrorists. And the subrogation provision has nothing to do whatsoever with purposes of TRIA.
Right. So Judge Randolph was asking you, are you arguing for a less mechanistic application of Article 4A, or that we should fashion a different federal common law rule? And you were, I think the bulk of your response was in opposition to the mechanistic application of Article 4A. And so affirmatively, the rule you're asking us to apply is?
I think what the court said in Heiser is sufficient.
But Heiser was not determining affirmatively the property interest of the originator. It had a much easier task. We had a much easier task there, which was to simply say that North Korea, as the ultimate intended beneficiary, had under no reading a property interest. And so the sort of throwaway line, which, it may indeed be valid, and I think, put some meat on those bones, that it's unraveled toward the originator, but is there nothing more sort of rigorous that you would offer for how we look at that?
I definitely would not call it a throwaway line. But what the court did in Heiser, on our view, was, as it says, applied the principles of Article 4A, and that those principles be what informed the federal common law. We have provided in our brief other common law principles that have deep roots that support that rule in Heiser.
Right, we've kept you a long time, but let me just follow up. You say the principles of Article 4A, but Article 4A and its distinctiveness from preceding common law is precisely to say, look, if you want, if you're a creditor and you want to go against either the originator or the beneficiary, you have to do it before the EFT gets going or after it finishes. Like, to the extent that the UCC for Article 4A is distinctive, that's what it's about. And I get your point that seems to be in profound tension with TRIA, to the extent that TRIA is saying where assets are frozen, go against them, and assets are almost inevitably frozen in the middle of a transaction and often an EFT. So I'm just curious in what respect you're still looking to the principles of anything to do with Article 4A, or whether you're looking more generally at agency or pre-Article 4A common law.
It's the principle, the overarching principle of Section 402, right? So I would, just to respond, Judge Pillard, to your point about Section 502 and 503, I would say, take it a step further. It's not just intention. I would say PREA preempts those provisions to the extent that they would limit the attachment of a blocked EFT.
Yeah,
thanks.
Right.
Thank you.
Now we'll hear from Wells Fargo. Good morning.
Good morning. Let's see if I can untangle my mask from my glasses.
I hope you can untangle this case, too.
I was going to try, Your Honor, to stay very neutral, but I may not be able to help myself from taking a stab at doing a smidgen of untangling. May it please the court, Alex Lucados for Wells Fargo. As everyone here, I think, totally appreciates, Wells Fargo as a neutral third-party garnishee, and I would just take the opportunity to say the bank is extremely sympathetic to the plaintiffs who have been victims of atrocities and their desire to get these funds. We're also extremely sympathetic to the victims who would get money through the government fund. Where we come at this, and I will get to doing just a smidgen of trying to untangle as I go along, is that this court noted in Heiser that any interpretation of TRIA should really avoid the risk of punishing innocent third parties. And in particular, this court called out avoiding punishing a garnishee by exposing the garnishee's own assets to a risk of loss. And unfortunately, this is the type of case that poses a meaningful risk of exposing neutral garnishees like Wells Fargo to multiple lawsuits, to inconsistent rulings, and potentially, if everything goes through a series of cascading failures that I've worked many decades to help Wells Fargo avoid in many of these cases, a risk of duplicative liability. If you look at this case alone, for example, Your Honor, we've been sued by the Levins. We've been sued by the Owens plaintiffs. We've been implicated in forfeiture proceedings. This is in DC. This is in New York. This is in South Dakota.
Why are these funds being held in South Dakota?
That's a great question, Your Honor. So two answers. The OFAC regulations.
Is Fargo in South Dakota?
We have presence there, and I guess for book reasons
No, I mean
or
the,
tax reasons.
the town.
I'm sorry?
The town.
Oh, I don't know. I think so, yes.
Is that why the bank bears that name?
So what the OFAC regulations say is that once we've blocked it, we have to put it in a separate segregated account. So that's a matter of regulation. So then it's just a question of, well, where is that account? And for whatever regulatory or historical or tax reasons, and I genuinely don't know, this decision was made decades ago, that account for all the blocked assets all over the country would just be segregated in South Dakota. But why? It's a book entry, right? It's an electronic thing that the bank does.
Right. Is it earning interest?
Yeah, statutorily, I believe there has to be a certain amount of reasonable interest. It's very minimal. From a bank perspective, and we're not complaining, this is a cost of doing business. It's just a slight burden. It's something we have to do and maintain, and it's a bit of administrative headache. It becomes a much bigger headache, of course, when everyone comes to fight over the assets. So look, our primary interest is ensuring a rule of law that doesn't expose Wells Fargo. And this is where I'll take a shot at doing some untangling. It seems to me that there are two choices, right? If this court were to affirm, it seems to me that the way that would be done is just a very straightforward, we believe Article 4A of the UCC applies. We're going to stick with it. The district court got it right. The Owens plaintiffs acknowledge that if you follow every jot and tittle of it, in their words, that they lose, that they're out of luck. And so that's one way of doing it. And we sort of urge that there's some logic to doing it that way, right? You don't split with the Second Circuit. Conversely, if this court is going to reverse, and there are some really good reasons to do that, to be honest, because it really does seem to us to make a certain amount of sense that if TRIA is trying to help out these victims and all these assets are being blocked midstream, that they get a shot at doing that. The way that I think intellectually, honestly has to be done cannot be done by squinting at Article 4A until somehow it allows it, by some sort of machinations with the money back judgment rule, by putting a tremendous amount of weight on one sentence in Heiser. And if your honors look at that particular sentence, which the sentence says you wind back to the originator, what that sentence says in full is, we think the district court got it right. You wind back to the originator, cite to the district court. And then when you look at what the district court said, it says the originator or the originating bank have the claim. So I think that one sentence doesn't establish that it's necessarily the originator that has the claim and the interest there. It just doesn't do that work. And so if this court is going to reverse, I think the way it gets there is through the Massachusetts rule. And that's an intellectually honest and legitimate way to get there. And what we would say from Wells Fargo's perspective, if I may, is that should the court go in that direction, we would simply ask that the court, as part of crafting federal common law, make perfectly clear that what that does is it displaces the UCC so that we don't have a situation where this court says, hey, federal common law, the Massachusetts rule carries the day, Wells Fargo, please pay out these monies to these victims. And we do so, and then Lloyd shows up and Lloyd says, well, gee, the UCC is still in effect. We want you to pay us now. So to just make clear, and this is what. Yeah, I know. Yeah, right. This is what Judge.
That's Judge Sims' point.
Exactly, Judge Randolph. And the plaintiffs, who advocate for this rule, hold up Judge Chin as being, the guy who gets it right, the judge who gets it right in terms of how this ought to be done. And we would just say, please, if you go in that direction, also do what this court has admonished, which is to protect us as a neutral third party and simply say.
Let me suggest to you, I'm going to read something and see if you agree with it.
Sure.
That with respect to the application of federal common law, it should be done as to a single issue at a time and requires federal courts to consider whether the issue's outcome is consistent with the federal program. So in other words, you take a look at it, you take it issue by issue by issue, and rather than a global approach, which would be somewhat equal to what the Second Circuit is doing. Do you agree with that statement? You take it issue by issue, whether you're going to adopt a particular state law program.
Your Honor, I believe I do agree with that, but I'm trying to see the next move down the chessboard and make sure I agree with what the implications are. I think if the question then becomes, in taking issue by issue, is it fair to get to the protection of Wells Fargo that we're asking for? I think the answer is definitively yes, it is, because part of what Judge Chin says is, look, in applying this common law and figuring out, does the terrorist have the exclusive interest, because you can only, as sort of common law 101, you can only attach as much as the terrorist owns, and in making sure that the terrorist has the exclusive interest, we need to make sure that the upstream banks have stepped aside. And so I think it is part and parcel of addressing this one narrow issue to also say, we need to make sure the upstream banks have stepped aside. Either we're going to deem them wiped out, or we're going to require as a precursor that they agree to waive their claims or step aside, as happened in
Couldn't all this be accomplished in your submission simply by holding that the exception to the subrogation rule in 4A makes no sense when you're dealing with block assets? Because you're not going to have subrogation anyway.
Yes, Your Honor. I think that 4A was, as plaintiffs argue, I think rather convincingly, 4A was not designed for this situation. And once the assets are blocked, you're in a whole different world where the considerations that animated
4A can apply.
Sure, it can.
As in situations in which there is no disconnect because of the failure of the originator bank to follow the instructions of the originator. In that situation, 4A is, it shows you who has the interest. And if you're following 4A, it enables the government, number one, to block the assets, and it also enables the debtors to collect.
So, right. So the trouble that comes up, right, is that rule of 4A, which makes really good sense when you're trying to allocate who has the risk of a bank failing, starts to look a little arbitrary when you're saying who gets to go after the blocked assets of terrorists. And that's where it gets to be a little bit uncomfortable, possibly, to follow 4A. Now, in terms of...
Wait, just on that. So
yeah, sure.
It's not just the subrogation which rule applies, it's also the nature, as the district court quite methodically showed, that the property interest is divested from the originator and moves along through the EFT. Isn't that the other major obstacle to using 4A as the source of the property definition under TRIA? Because then it's not going to be terrorist property where it's found. And that is not wrapped up, is it? Or maybe I'm missing something with the subrogation.
Yeah, no, I mean, and this is part of what makes a very literal and strict interpretation of 4A complicated for everyone, right? Because the government also, OFAC takes the position, and I think the government takes the position that these assets are attachable by the government, these assets are blockable. Maybe OFAC's a bad example because it has a much broader remit in what it considers attachable. But yeah, if you take it literally that there's no interest whatsoever by anyone other than the immediate upstream bank, and that's the only interest you recognize, then I think it puts the government in an awkward position as well. And then we are in a world where, again, it's a little tricky to make 4A really work perfectly here because it just wasn't designed with this in mind.
In fact, quite to the contrary. Its whole point, I thought, was to shield the intermediary, the beads along the chain of an EFT from creditor action. Shield them. And so to say we're going to borrow anything from Article 4A for the purposes of TRIA seems to me that you're mixing oil and water. And obviously, my understanding of this is very rudimentary compared to yours. But am I missing something in thinking that that the whole benefit to the financial world and to banks of 4A seems inimical to what TRIA is about.
I don't think you're wrong, Your Honor. I really think that 4A is really about not letting courts jump in the middle, not letting creditors jump in the middle, and protecting transactions moving very quickly so that you either under 4A, you stop them before they go, or you stop them when they arrive, depending on who owes you the debt. But that you don't stop them in the middle, and therefore commerce and banks like Wells Fargo move hundreds of millions of dollars a day, and this is good for all of us who want to be able to pay our mortgage because our money arrives on time, not to have that. But once the money is blocked,
It's a different world. And you were saying, I interrupted you when you were saying that OFAC says these are blockable, the United States, you were going on, and
Yeah, and I apologize for that. So I guess what I was just saying is in full agreement with you, Your Honor, is that, the U.S. government is going to say that, they can forfeit these assets in the middle of the transaction that are blocked. And that seems to presume some sort of a property interest, which read very literally 4A doesn't seem to contemplate exists.
Although as was pointed out, I think there is a difference in the wording. The forfeiture statute is more broadly looks at interests, and we haven't so far read TRIA quite that broadly. But point taken, there's a tension there.
Sure. All right.
Anything more?
Yeah. All right. Thank you, Your Honors. Very much appreciate it.
Thank you. Now we'll hear from the United States.
Good morning, Your Honors. May it please the court, Brian Hudak from the U.S. Attorney's Office on behalf of the United States. I want to pick up where my friend from Wells Fargo left off about what interests are at play, and why can the government block these funds, forfeit them, while TRIA creditors cannot attach them. And the reason is because the interests that are blockable under OFAC regulations do far exceed mere ownership interest. As this court recognized in Heiser, OFAC can block interests or funds, even though Iran had no traditional legal interest in them. I would also direct the court to JP Morgan Chase from the Second Circuit, where there's a lengthy footnote from the Second Circuit explaining the difference between ownership interest necessary for attachment by creditors and what can be blocked.
That makes a lot of sense. I see the delta between the definitions of the interests under the two statutes. But I guess I have two questions. What is left of TRIA under the United States' reading, and how long has the United States taken the position that it's taken in this case? Has the United States taken the position it's taken in this case in prior cases?
I believe the United States has consistently taken this position in the Second Circuit and here. I don't believe it went on fully on the record in Heiser with regards to this position. I think the question in Heiser that the United States weighed in on in a statement of interest that was a suit between private parties was whether TRIA required an ownership interest in funds for them to be attachable under TRIA. And the United States answered in the affirmative, which this court adopted in its opinion in Heiser. But Your Honor, just to get back to the delta as well, why we can forfeit.
No, my other question was, what is left of TRIA?
Sure, my apologies, Your Honor. What's left of TRIA is the ability to go and recover against accounts that are blocked under OFAC regulations. So if Iran or an Iranian front company or an instrumentality of Iran has a bank account at a U.S. financial institution that OFAC blocks, that becomes, obviously, it's property of the instrumentality or agency. It's blocked, and thus TRIA applied. The main issue that TRIA was designed to prevent, as I understand it, was that exact circumstance where the United States would go and block a bank account of Iran and say it's OFAC blocked, no one can touch it. And what Congress did with TRIA before it enacted the compensation fund statute was to say, no. Creditors, terrorist victim creditors under TRIA can go and collect against that account that the United States blocked, notwithstanding the OFAC blocking or IEPA or the executive order.
So you acknowledge that more or less the situation of intermediary accounts or correspondent accounts which are used sometimes by terrorists to transfer money, that is basically taken out of the realm, but by your interpretation, that's kind of taken out of the realm of recoverable sources of recoverable assets under the TRIA. So it's more if there's just actual property or an account in the U.S.
It depends. If there is a terrorist organization that is the financial institution who is serving as the originating bank. So if I'm serving a bank that's serving and trying to process a U.S. dollar transaction through a U.S. correspondent account, that would still be attachable under TRIA because the originator bank is the one that has an ownership interest in the funds that is being blocked at the intermediary bank.
The bank or the bank's client?
The bank.
So if the bank then has to be the terror defendant?
Correct. So, or an instrumentality, a front company, a financial institution that is truly an instrumentality or agent of a terrorist state or a terrorist organization, that bank, that financial entity, if they have an ownership, if they are truly a terrorist entity, they have an ownership interest in funds blocked midstream. They are the only one in blocked funds under Article 4A that have an ownership interest as the second, as plain reading of the Article 4A and as the Second Circuit has held. Judge Randolph, to address a few of your questions, the actual wire instructions are in the record. If you look at Joint Appendix 273, that is the SWIFT transaction record from Lloyd's Bank, indicating its election to use Wells Fargo as the intermediary bank for the transaction.
What is the government's position, or how does the government explain its authority to block these funds?
Sure, and
what is the interest that enabled, what is the Iranian interest that enabled the government to block these funds?
So, Your Honor, the definition of property and property interest is quite broad under the OFAC blocking regulations, and we would say it is a future, as far as forfeiture goes, it's traceable to a violation. That's all we need. It doesn't need to be the property of, it has to be derived from or traceable from a violation for it to be forfeited under the forfeiture statute. Under OFAC's blocking regulation, it's a paragraph long, but it includes things such as—
What's the citation to that? I haven't looked at it.
31 CFR 594-309, and it is in the Owens appellant.
594, what?
I'm sorry, 494.309.
Okay. Okay, go ahead.
And also, Your Honor, I would direct the court to the JP Morgan Chase decision from the Second Circuit, where it describes that. It's 899 F3rd 152 at note 4, where they describe the difference in scope between the blocking powers of OFAC and the attachment remedies of TRIA, addressing that particular
I'm sorry,
issue.
that was footnote 4 of?
Footnote 4 of JP Morgan Chase from the Second Circuit.
Thank you.
Your Honor, in talking about what Holman Fenwick's role was in the transaction, we do understand that they had a separate retainer agreement to provide certain legal advice to TAFE during the transaction, but their role as the holder of the account, they expressly disclaimed being a fiduciary of either Crystal Holdings or TAFE Mining. So in that role where they're holding the funds and are an escrow agent, they aren't acting as an agent for purposes of ownership for TAFE Mining. That would, again, TAFE Mining is ultimately the one that ended up with the ship, albeit through illicit means. So it's a question about how does TAFE Mining continue to have interest in these funds when it's received the benefit of its illicit bargain. That is, that it has the oil tanker, it's in Iran after it was hijacked off the coast of—
So under your view, under the UCC, Holman is not an originator?
Holman would be the originator here. As we understand it, Holman Fenwick, if you look at the SWIFT transactions—
Holman is the originator.
It is the originator, not TAFE Mining. The Holman Fenwick, an international law firm, is the originator. So even if you go from a factual standpoint and don't want to address the legal issue here, TAFE Mining, the only Iranian agent or instrumentality, is not found in any of the transaction records for which this wire was transacted. So the court didn't resolve that below. Instead, it relied on the Article 4 resolution. But if the court wants to resolve it on that factual ground, it certainly can do so. The United States also offered, and I know my time is out, but the United States also offered other reasons why these writs should be quashed at the district court, including because they are no longer blocked assets of a terrorist organization. Once the United States obtained its OFAC license and seized them in forfeiture, they ceased being blocked under IEPA, and instead they are seized under forfeiture. And
Although
that
the
is,
forfeiture is not complete?
it is not complete, Your Honor. Just so procedurally how we got here, we got writs of attachments on these funds after the United States executed its arrest warrant on the funds, filed its forfeiture complaint. Wall Street Journal learned that these were at Wells Fargo. We did not advertise where they were, in all honesty. And then creditors came in to try to attach these
So
funds.
you arrested them before they sought to attach them?
Correct.
So even if we were to disagree with your property analysis, there's a first-in-time battle to be had?
Correct. And that time would come in the forfeiture action, presumably if the creditors have an identifiable property interest in the race of the forfeiture action, they would have standing to file claims in that action. And at that point in time, we would resolve the first to file.
The United States will always have be first in an attachment to block funds. Isn't that correct?
That would not be correct, Your Honor. So there are situations where OFAC blocks accounts and blocks transfers where the United States does not seek to seize, arrest, and then forfeit them. There are certain circumstances like that. And in fact, I think those are circumstances that led to various recoveries and other victims that are pursuing recoveries in the Second Circuit, where there was blocking, but the United States did not seek immediately to forfeit.
Is it your position that once the United States gets priority by the first writ of attachment, that therefore that other debtors can't come in?
The United States' position is once they're seized or arrested in forfeiture, no one can come in and supersede the United States' interest at that point. That's not before you, because that would be a priority interest that would be battled out in the forfeiture action. Should these writs be sustained?
Where does that rule come from?
It comes from, Your Honor, I think just property interest, first in time, first in right, in the common law. It also comes from the forfeiture statute, saying that after an asset is seized and arrested in forfeiture, no other court can issue orders regarding it.
What do you do with the TRIA provision that says that notwithstanding any other law, which is why I asked you where it came from, and you said the common law. What do you do with the TRIA provision that says notwithstanding other, the debtors, the people having a judgment against Iran can recover?
And Your Honor, I have an answer, but this is why we would ask the court to exercise restraint on that point, because it has not been fully briefed. Notwithstanding any provision of law, this court has tackled with that phrase in numerous cases over numerous years. It has said that that phrase, in certain circumstances, when it comes to statutory jurisdictional requirements, does not create an exception to those statutory jurisdictional arguments. But this issue has not been fully briefed before this court. And
well, I understand that, but it seems to me that has some implication with respect to what rule of law we're going to use in determining this case.
Sure. Yes, Your Honor. And this, if the court rules that these writs should remain and reverses on that basis and remands for proceedings non-inconsistent with its order, there may be other issues that bubble back up to this court, including the, again, not blocked, but seized and arrested in forfeiture. And that's not an argument that we make out of whole cloth. That's an argument that the Fifth and Seventh Circuits have adopted in similar circumstances with regard to assets. That once the government has an OFAC license to effect the forfeiture and has arrested or seized the property, that it is no longer blocked under IEPA, but is seized or arrested in forfeiture, and thus TRIA wouldn't apply. TRIA only applies to assets that are blocked under IEPA. So there's alternative grounds to quash the writs that we would ask the court, if it is going to reverse on the Article 4 ownership interest issue, that it reverses and remands for the district court to consider those other arguments.
I'm sorry, Mr. Hudak, you were saying something about that the notwithstanding any provision of law and how that, how the courts have struggled with that and the meaning that they have given. And you said something about jurisdictional provisions, but.
So it's not arising in this context?
Yeah.
There's at least
no,
one
I understand
case.
that, but just thinking about the,
Sure.
the coherence of the neighborhood in which we find ourselves Your point about why the notwithstanding language doesn't get in the way, as Judge Randolph was probing, is...
Well, the United States believes that it, notwithstanding provision of law, only applies to statutes and regulations. So it doesn't preempt common law. It doesn't preempt, for instance, the sovereign immunity of the United States. It doesn't preempt the prior exclusive jurisdiction doctrine, which tells that once one court exercises in rem jurisdiction over a piece of property, other courts...
The Supreme Court has rejected that position, though, hasn't it? That when it talks about law, notwithstanding law, that it doesn't apply to common law. The Supreme Court rejected that, didn't it? In Erie Railroad versus Tompkins?
Your Honor, I don't believe that's...
You know that case?
I understand, but this court has struggled with notwithstanding any other provision of law, and at least there's another case coming to you in this similar realm of asset forfeiture that the notice of appeal was just filed, where this issue is squarely teed up in the context of the United States' sovereign immunity. So again, this is another reason why I would urge the court to exercise restraint on that issue, given that that will come up, if it does come up in this circumstance, when we turn to the forfeiture action, if the court does reverse.
Yeah.
Thank you, Your Honor.
Thank you very much, Mr. Hudak. So I gather, although we've taken you way over your time, that Ms. Smith and Mr. McGill had hoped to make brief rebuttal, and we'll give you each 2 minutes. And this time we actually mean 2 minutes, although my colleagues are free to extend it.
Yes, Mike, when they talk, that doesn't count against my time, does it, Your Honor? So to answer one of the questions that Your Honor asked about, are there any assets left if you take away EFTs for the victims to go after? There are none. As Judge Randolph quite rightly said in one of his comments, the terrorists are not stupid. Iran is not opening bank accounts in the United States, and neither are its agents or instrumentalities. However, EFTs, interestingly enough, are put into blocked accounts. What we're talking about now is a blocked account held by Wells Fargo. TRIA talks about blocked assets. It does not mention property, but this court in Heiser said we're interpreting TRIA to mean property of the terrorist or its agent or instrumentality. So one thing I will leave you with, I cordially slightly disagree with my colleague from Gibson, Dunn & Crutcher, who represents the Owens. I believe, as the professors, the amicus briefs, if please you will read those, who try to walk you through Article 4, 4A, 402. There is a subrogation section, which is an E, but leave that aside for a minute. Forget about the subrogation section. Sections C and D of 402 talk about the money-back guarantee, which Heiser mentioned, and which the professors try to explain is what creates a property interest that remains in the originator all the way down the line, no matter how many banks it goes through. And they refer the court and everybody reading their briefs to the comments to Section 4A 402, which talk about the money-back guarantee. And one thing that the comments say is this money-back guarantee assures the originator it will not lose its money if something goes wrong in the transfer. Now, that's just the comments, for once talking in sort of lay terms and trying to lay out something commonsensically. But C and D create a property interest. This court did not hold that it had to be 100% property interest under TRIA, but a property interest. So the originator has a property interest. It is not lost in the process of these transfers, and it is not lost even when the subrogation rules come into effect, unless the originator has chosen the transferee bank that the money is placed in, and that's where it gets lost. If it's lost there, then the originator is subrogated to its bank and it bears the risk. So I know it's a mouthful and a lot to look at, but I hope you will consider the amicus briefs in particular, because I think they do give a good roadmap to the UCC and its intricacies. But I agree with my colleague, you can get there another way. Thank you.
Thank you.
Thank you, Your Honors. A few quick points. First, I want to underscore that there is no innocent third party here at risk from the rule that we urge. Lloyd's has never asserted a claim in 2 years, and I think the court here fairly could, in this particular case, deem Lloyd's to have disclaimed any interest in the funds, or in particular, any claim against Wells. The second point, to Judge Randolph, you asked what is the interest that permits the blocking here, and I actually never heard an answer from the government. The government says, and I agree, that it doesn't have to be ownership, that the blocking regulations are broader, but it does have to be identifiable, and it has to map onto the facts of the case. And the government has been very coy and has not actually asserted what it is. We heard, the most I heard was something about a future interest. I don't know what future interest TAFE could have in these funds under their view of Article 4A. What is left of TRIA, you asked Judge Pillard. The government said, well, you could have situations where there are Iranian originator banks doing using U.S. correspondent accounts. That cannot happen. U.S. banks cannot accept transactions from Bank Melli or Bank Satarat or Bank Markazi because they are sanctioned entities. So it would only be by mistake that would happen. The government says Holman is the originator. Talk about a loophole. This is like worse than Vladimir Putin owning houses in the name of his violinist. This is an agent of the originator. It is their attorney. And again, I would point the court to the power of attorney document at JA 117. Finally, on the point about the priority, I just point the court to our reply brief at page 14 and the footnote there. The forfeiture warrant, strangely, has never been returned in this case, which perhaps raises jurisdictional issues for the government. My very last point is that the government's position here leads to this very strange and arbitrary and incongruous outcome where TAFE is if only TAFE's instructions had been followed, TAFE would be the owner, but alas, they weren't, so they're not the owner. And I would say when this court is developing federal common law, it can and should do so in a way that accords with the statutory purpose at issue and does not lead to such arbitrary and incongruous outcomes.
Thank you. Thank you, counsel. The case is taken under advisement.